PFAS litigation, specifically securing municipal remediation funds. Michael Stag and Ashley Liuzza from the firm of Stag and Liuzza out of New Orleans, right? New Orleans, sorry. New Orleans.
Is this the clicker?
Yeah.
Good morning. So, as you said, we're the lawyers, and I know I heard a couple things about lawsuits and lawyers, and ultimately the reason why we're doing what we're doing is because of everything you heard about here, all the regulations that are coming into effect, and the pressure point that we're seeing with municipal clients and even private water supplier clients and how they're impacted by this. So ultimately, there we go. This all started a long time before I was alive and before many of you were alive, and it'll go on beyond our lifespans. When I give this talk to lawyers, I usually talk to them about a comparison to asbestos litigation and asbestos in our environment. And ultimately, this is being considered to be an even longer and larger project than asbestos was from the litigation side. Ultimately, we started seeing the development and use of PFAS very early, and the main culprits kind of were 3M and DuPont. And so in the litigation, we're not suing municipalities, we represent municipalities. We're looking to the chemical manufacturers and saying, this is a product that you put out there, it has caused a problem for drinking water, wastewater, landfills, airports, and how are we going to respond to that? I know that Taryn mentioned dark waters, and that was some of the early litigation. Rob Billot, who's involved in this case, was also, he was the main lawyer. Mark Ruffalo was him in the movie. And so ultimately, that's an interesting thing. If you haven't seen the movie, you should watch it. But from that case, we actually got a science panel. So the C8 science panel studied the effect of PFOA and said, what are we really looking at? Do we have health problems here? And so that's years before the current litigation in the early 2000s, and the study came out in 2013. Ultimately, this MDL, which is multi-district litigation, focuses on PFAS through AFFF or firefighting foam. And so ultimately, to be in the litigation, you had to have an allegation that at least part of your PFAS contamination was from AFFF. What we've seen through modeling and other information, including a lot of the DoD information, is that AFFF was one of the primary mechanisms to get PFAS into water and other areas. So from the C8 panel, there was lots of information that came out. Ultimately, I think there were 6 diseases that they related to PFOA exposure. And what we've seen since then, since 2013, is the science has developed to show that PFAS impacts basically total body systems. Ultimately, does that mean that every single thing on here, if you have it, it's definitely caused by PFAS? No. And that's not what the litigation says. But what it says, and this is a driver for some of the regulation, is we know this is a problem. It's in our drinking water. It's in this closed system of drinking water, wastewater. It's going out into agricultural delivery. It's in our cheese. So how do we deal with that? The litigation is huge. Even though it's AFFF, it goes across public drinking water systems, wastewater systems, property contamination, many of the things you talked about that are being regulated today, airports, landfills, fire training facilities, that's all in one case. States, all in the same case. Personal injury, firefighters who were exposed and have one of these, what we call the leach injuries that were from the C8 panel, they're in the same case. So ultimately, one judge in South Carolina has all these cases from across the country, and it's his job to say, how do I move this case along? A big focus early on for him was drinking water. He said, this is a massive case, but ultimately we know the way a lot of people are being exposed is from ingesting water. He also saw that there was a little bit of writing on the wall about the regulations. This case I think it became an MDL in 2019. And so we knew the EPA was going to act. We saw some states were already acting, and he knew there was going to be an unfunded mandate. And ultimately, if that's the standard that stays in place, it is going to be very expensive. And so how do you, as a municipality or a public water supplier that is a private entity, how do you deal with that? The government doesn't necessarily have enough money. The government may not be as generous with the money right now. And so ultimately, we have to look to the creators of the problem, essentially. Our clients, we represent municipalities in about 30 states. It's the spectrum of politics. I can tell you the common theme is most of them don't like lawsuits. Most of them don't love lawyers. But they don't like having this problem that they have to deal with, and they don't like the fact that it could go on to their community in terms of, will they have to raise taxes to get this mandate, to satisfy this mandate? So that's been a driver in the litigation. Is we know the EPA we knew the EPA standards were coming out. They're out there now. A lot of our systems are in states where there were no standards in their state, or there was no consideration. We're from Louisiana. I still talk to mayors and people in the state who have never heard of PFAS. And it's a little bit alarming because they do have this mandate now, and sometimes the water guy knows, but no one else knows about it. And so really, we're trying to educate them and provide them with the tools through this litigation to get what they need to implement certain things, put in new systems. We saw, so one of our early clients was a Massachusetts client. Massachusetts had early regulations themselves, and our client had to put substantial capital improvements in place. Ultimately, they were able to fund it, but it's one of these things where it was at that level. They have additional wells that they have to take care of. Their treatment facility may have to be updated, and that was just one system. And we're talking about, tens of millions of dollars, not even for a very large system. So when we talk about some of these really, really large systems, it gets even more complicated. The big thing that we're getting from our clients is, if we do this lawsuit, are we going to be able to get the past damages, and are we going to be able to get the future? Because they know, well, if we have PFAS in our system and we update our system, is there going to be increased filtration costs, the maintenance over time? It's really a burden on your system if you have a high level of PFAS. And as some of these other things develop, the regulations, how are you disposing of the material that you're using? And it's a lot more complicated. And so ultimately, we're seeking funds for that type of stuff. So this is just some of it's from about 6 months ago, we put this together, some of the older state regulations. And so you can see there weren't a whole lot of states that were acting, and it was kind of concentrated in certain areas. Ultimately, this is what everyone was looking at and kind of working on, and then the EPA standards came out. And so now we know there are these requirements, and this is just for drinking water, right? The first part of the litigation, that's been the focus. There are some settlements that my partner is going to talk about in terms of what was achieved and what municipalities can get. But ultimately, these are real things, and it's going to cost a lot of money. And so who should bear the cost for that? Ultimately, there's lots of details in terms of monitoring, notification, treatment, like when you have to do certain things. And we expect, even though there may be like a pause or a slowdown for some of the other aspects of the litigation in terms of the regulatory side with wastewater or biosolids, airports, landfills, we're going to see something similar. It may not be the same numbers, it may come out a different way, but ultimately we're going to go there. And so as part of this litigation, we're telling our clients to be proactive, look into it, get the information. Knowledge is power, and it helps actually inform their decisions in the litigation as well as moving forward in the case. The case is going to go on for a long time because it's so big. And so hopefully these mechanisms, the settlements that we're getting, will help fund additional relief. And so my partner, Mike Stag, is on the leadership for this litigation. He's going to talk about some of the settlements that have been put in place. I don't know what just happened to the PowerPoint. There we go.
Hi, my name's Mike Stag. I'm a lawyer out of New Orleans, but we represent clients all over the country. Ashley and I do mostly environmental litigation, always representing, public entities, landowners, folks who are impacted by pollution and are trying to either clean up their property or recover damages related to their property. We've been doing that for a long time. How does a lawyer out of New Orleans end up doing this all over the country? Louisiana has a lot of dirty old oil fields. That's a short answer. We have a lot of refinery, a lot of petrochemical industry. So there's a lot of opportunities for lawyers to litigate in this arena. And of course, Deepwater Horizon happened. We represented about 4,000 clients in Deepwater Horizon, both business owners, public entities, private individuals who lost a lot of money because of beaches shutting down, businesses closing, and also property damages, oil on beaches, et cetera. And doing a lot of that litigation got us on the course of doing these kinds of cases. And I thought Deepwater Horizon was going to be the biggest environmental case that we would ever be involved with. But this one is much bigger. Deepwater Horizon, of course, impacted the Gulf states. This impacts every state in the Union. There is PFAS everywhere. There's PFAS in all of our bodies. You could get a blood test from our friends at Eurofins, and it'll give you an idea of how much PFAS you have in your body. And so it's a wide-ranging issue, something that is very broad, and as Ashley mentioned, is going to go on for a long time. To give you context about this case, everybody's heard of a class action. All right, and a class action is just a procedural mechanism to deal with large legal issues. You have many clients, and in fact, one of the procedural requirements of a class action is you have numerosity. A lot of individuals who have the same damage claim or something similar. And there's a lot of other procedural hoops you have to jump through to certify a class action so that the courts can handle large volumes of individuals who are impacted and allocate money if they're successful in proving their claims. Class actions over the years have gotten harder to certify. There's a lot of, the jurisprudence has just evolved, so it's much more difficult to certify a class action. And because you have claims, because we have a very large economy and we have a lot of products that go all over the world and the country, sometimes you have issues with product defects. And these product liability claims now you're starting to see things called multi-district litigation. And that's a way for the courts, again, to consolidate all of these claims from all over the country, individually filed claims, and put them in one court. And so that's what they've done here. Tens of thousands of lawsuits have been filed over many years. We started this back in 2019. And the courts decided to put them all in front of one judge to administer all the cases. And as Ashley mentioned, if it has anything to do with AFFF, you end up in front of Judge Gergel in Charleston, South Carolina. And Judge Gergel is dealing with airports, wastewater, sewage treatment, public drinking water, state sovereign claims, all kinds of claims. And he's taken the approach of eating this elephant one bite at a time. And the first bite he took, and the way MDL judges typically handle these, is they deal with a lot of the common issues, gathering the evidence from defendants and plaintiffs, exchanging information, getting all that done, making some key rulings on pretrial issues, and then they set a bellwether case. A bellwether case is kind of like a test case, so that they can get an idea, both parties can get an idea of, who has the better evidence, who might win, what might a verdict look like, what might a jury think of this. And on the eve of the first bellwether case in 2023, which was in Stuart, Florida. 3M and DuPont agreed to settle. And they didn't just settle with Stuart, Florida, they settled nationally. All right? And the way they settled was in a class action settlement. Oftentimes, defendants oppose class action certification because it can mean a lot of money, but sometimes they'll agree to a class settlement because it gives them broad liability in exchange for paying a lot of money. And that's what we have here. This is a class action settlement with 3M and DuPont, and it is only for public drinking water systems. It does not include those other entities that we talked about. Those other entities are unsettled claims. They're still being litigated. I expect there will be future settlements for them in all probability. I can't guarantee that, but I think there will. But for public drinking water public drinking water systems of a certain size, with 3M and DuPont, they have settled their claims. And so it is about $14 billion in total. 3M is putting up $12.5 billion. DuPont is putting up $1.185 billion. And they have a phased payment schedule. 3M pays 3 equal installments over 3 years. DuPont pays 2 installments over 2 years. Now, this settlement is complicated, and so I'm going to talk about it in broad strokes. As you might imagine, what we're talking about is a very voluminous legal agreement with lots of exhibits and lots of legalese that designs, how they're going to pay and what they're going to pay and who they're going to pay. And to this agreement, they attached some exhibits. One of those, they're called the Phase 1 list and the Phase 2 list. And they're actually lists of public drinking water systems. And they're identified by their PWS ID number. And they divided the water world into 2. We're going to put half the water systems on Phase 1 list. They go first. Their deadlines are first. Their deadlines have passed now. So if you were a Phase 1 public drinking water system and you did not opt out of this class settlement, then you have settled, released your claims with 3M and DuPont, and you will receive no money if you did not apply for any money. So you got nothing in the bargain for that exchange, and 3M and DuPont go on their way. We're in the Phase 2 part of this now. One of the reasons we're talking about this is to get the word out to public drinking water systems that you may have a claim, and it may be a very valuable claim, but if you did not opt out, you're in this settlement, whether you like it or not, and you have to do some things to participate in that money. You are owed this money based on this contract, which is an agreement of releasing 3M and DuPont in exchange for, that release, getting an allocation of money. And this money is designed to fund sampling, fund remediation, or pay for past, enhancements to your public water system. It won't get you all the money. It's not designed to get you 100%, but it could be substantial reimbursements for some of those costs. And there's also a special needs fund, which I'll talk more about, which is if you have expended costs, you can apply to get some of that money back. Sorry. All right, this is what's called the allocation table. And there are 2 of these. This one relates to 3M. There's another one for DuPont. This is not a table that I created. This is a table that was created by the settlement committee to give public drinking water systems a good idea of the potential amount of money they could receive in settlement. It is a little bit of an oversimplification. It doesn't, there are lots of different aspects to this, and it's not meant to be 100% accurate as to how much money you will get. But it's an illustration of the dollars and cents you could receive in settlement as a public drinking water system. This is related to the Action Fund, which is one of the funds within the settlement. And the way this money gets split up is based upon your flow rates, how much water are you processing, the idea being that the larger systems should get paid more money, and what is your PFAS score. The idea being that if you have more PFAS, your infrastructure costs might be higher, you might have to add filtration, you might have to change your filtration media more often, so you have higher costs. Therefore, if you have a higher PFAS score, you should get more money. You'll notice on this chart, and the PFAS score is based on some math done with various PFAS chemicals. The flow rates are based on 10 years of flow rates and your max flow rates and picking the highest ones and doing some math related to that. But generally speaking, the PFAS score is in parts per trillion. So you'll see, and this is important. There's a lot of confusion about this settlement. A lot of folks don't understand this. We're not looking at your finished water for this settlement. We're not looking at the water in your system. We are looking at your water sources. So if you have a reservoir, if you have a lake, if you have a river, if you have 20 water wells, groundwater wells, each one of those needs to be tested. Each source has to be tested, and then you get a PFAS score for each one of those sources, and you get your flow rate applied to each one of those sources. And so this settlement is designed to look at what are you dealing with? Your raw water, what's going into your system, not what's coming out. So your water can be perfectly safe, meet all state, federal standards, and you can still get money under this settlement. Yeah, okay. Most of these systems, kind of fall in the mid-range of this, where they're going to receive, even if you're at barely detected amounts of PFAS in your raw water, somewhere between $200,000 to $1 million. If you get above that regulatory bump, which is the 4 parts per trillion MCL EPA standard in your raw water, then you're going to get $750,000 up to $4 million. Some will get a lot more. And that's just on the 3M. There's also another chart for DuPont, which is about 10% of that. There's also a settlement for TICO and BASF. At this point in time, the deadlines to apply for the TICO and BASF money have expired. So, but they didn't settle with all public drinking water systems. That is designed to pay public drinking water systems if they had a positive detection before May 15th of 2024. A lot of water systems did not. Therefore, we're recommending that if you didn't, you would file a claim against BASF and TICO. I think they'll settle at a later date related to that. So what's important about the settlement is knowing what kind of testing you need to do. It's EPA mandated testing. The more important part is where. You do it in the raw water, your water source. There's also baseline testing. It's important to submit your testing so that you can participate in future money if things change. If you have a 0 today and you end up with a 4 or 5 tomorrow, you could get money on top of that up to 5 years from now. Also, there's qualifying expenditures. If you spend a lot of money on your water system, we can apply to get some of that money reimbursed as well. That's in addition to the chart I showed you. And we're trying to help our clients maximize their recovery because they're going to need every dollar they can get, especially if they have a big PFAS problem and they just, they're going to have to pass it on to their customers. So, that's part of what we're doing. Deadlines for phase 2. The first deadlines come at the end of this year or beginning of January 1 of next year. So I tell everyone end of this year is when you really need to get going on this. Get your testing, and then in the summer of next year, that's when you're going to have to do all your final deadlines, and we expect the first payment for phase 2 will be at the end of next year. As far as what's next, we still have a lot of work to do. There are additional defendants that have not settled with public drinking water systems. We think that the statute of limitations is tolling, so if you have a claim or have an issue, you should file a claim in a court of law to protect your legal rights. Everybody knows about PFAS. The EPA has issued mandates. Statute of limitations is certainly ticking at this point in time. There are also personal injury bellwethers. Those are folks who have kidney cancer, testicular cancer, 2 signature cancers associated with these chemicals and exposure to them. Those are going to trial in October. We'll see what happens with that. And then we need to litigate the other claims. You, again, have wastewater, sewage treatment, airports are a big issue. A lot of states have filed claims. All those are on the table and are all pending resolution and have not been settled at this point. So thank you very much. At this point, we'll open up to questions.
Thank you. Absolutely. Any questions from the audience? either for Michael or Ashley. Jorge, you want to start?
Yeah.
Excellent.
Thank you.
Has the judge indicated any timeline for the resolution of environmental damage claims?
There is no specific deadline. That's a good question. He's really trying to push it along and stage it. He hasn't set all environmental for deadlines. What he's done is, rather than set another bellwether for environmental deadlines, what he's doing is doing a product ID bellwether, which is basically a process where certain property damage cases, like fire training or sites that are contaminated, are having to show product ID, and that's forcing the parties to work on, who is contributing to this problem, in the hopes that it will force some kind of a grand settlement because of all that work they're going to have to do, showing who is relatively more liable for those environmental damages, so to speak. Yeah. Yes.
Dora Chen from Jacobs. I do have one question in terms of the treatment side of allocation, because with most of the time, the treatment technology do not actually destroy PFAS. They just remove it from the water sources, and then actually all ends up with some kind of waste, right? You have a spent GAC, you can have the sludge that turn into biosolids. So for those lawsuits, you're talking about a settlement, is there any discussion or determination in terms of those waste generated from those settlement or the facilities?
Yeah, I think you were talking about the waste solution, like how to deal with the waste problem. That's a good question. I think that's probably a question that the regulators are going to have to answer at some point. I'm really kind of like a fancy bill collector, honestly. We collect damages for recovery of losses, and so as far as solving the waste problem, I don't really have a clear answer for that. I do think it is a problem because if this stuff ends up in a landfill, it's going to get back into the environment and cause problems, and then downstream of that, who's responsible? If your property gets polluted, do you sue the landfill for contaminating you? And does the landfill sue whoever put the, those are all interesting legal questions that, quite frankly, I don't have the answer to yet.
Not to mention the sovereign immunity aspects.
Right, and the sovereign
immunity. I think Jorge
yeah.
does have an answer on some of the waste disposal.
Yeah, that's a good question. If you have read recently, Tampa International Airport is going through the transition process from PFAS containing foam to AFFF to fluorine-free foam. But they're specific in terms of how to handle this waste. They're saying everything needs to go to Emil, Alabama. So they're considering a hazardous waste from liability purposes. Same thing with Naples International Airport that just finished the transition from AFFF to fluorine-free foam. They send it out state and they injected everything. So from a waste management perspective, I think most clients, at least municipal clients, are considering this already a hazardous waste.
We've got time for one more question. I do want to caution you guys, the acoustics in this room are slightly worse than a cave somewhere. So if you've got a question, slowly we'll let us hear a little better. All right, or not. Oh, there we go.
I wanted to make sure other people could get their questions in. This is more of a curiosity about what's the reasoning for the discrepancy between how much DuPont is liable for and how much 3M is liable for? It was like a 10% difference.
Yeah, the reason is because of the AFFF liability aspect of it. 3M had a larger market share, much larger market share of the AFFF product, and that's why 3M paid so much more than DuPont did in this case.
But you'll expect that percentage to change in other liability?
It could in other liability cases, yeah. It depends on, this is very product driven. So, yes, that's right.
Can I follow up? So this is only driven by AFFF, it's not driven by like a, release percentage? Because I know DuPont also has, large amounts of release, but it's not specifically AFFF, it's more on the, cookware side.
I mean, you're right. DuPont has a lot of releases, et cetera. The plant actions, the claims against plant sites are carved out of this. In fact, that's a big part of the settlement design is you do have matters that relate to plant sites or pollution sites. That's not part of this. This is just the product liability piece of the PFAS problem on the public water side. So public water systems contaminated by PFAS through AFFF. Okay? All right. Thank you very much.
Thank you guys, it's been a great audience. Don't forget to tip your waiters and waitresses.